Law on Banking and Financial Institutions. November 18, 1999. Capacity of Directors and Managers. Chapter 6, Capacity of Directors and Managers. Article 18. No one may be member of a board of directors or supervisory board of a licensed entity, or, either directly or through an intermediary, direct, manage or run a licensed entity in any capacity, or be authorized to sign on behalf of such an institution if he 1. Has been convicted of a crime, theft, fraud or breach of trust, misappropriation when acting as a public depository, extortion of funds or securities, criminal bankruptcy, injury to the credit of the state, or breach of exchange control regulations, usury, money laundering, forgery and or the use of forgeries. 2. Has been sentenced to a period of imprisonment for issuing bad checks. 3. Has been convicted by a foreign court of law of one of the crimes or offenses listed in paragraphs 1 and 2 above. 4. Has been convicted in Cambodia or abroad for personal bankruptcy, receivership, or liquidation of assets. 5. Has been relieved of his duties as a law official by virtue of a court ruling. 6. Has been involved in a personal capacity in the management of a covered entity whose license has been withdrawn following a disciplinary action. Chapter 7, Composition, Permanent Identification, and Responsibilities of Partners in Covered Entities Constituted as Non-Commercial Societies. Article 19. The conditions applicable to setting up the capital, variable or non-variable, of the covered entities constituted as non-commercial societies, plus the permanent identification of members or holders of stocks, shall be defined in the special act applicable to cooperative or mutual societies, in compliance with the provisions of Articles 11 and 14-2 of this law. The central body shall be responsible for guaranteeing the solvency and liquidity of each network vis-a-vis third parties, depositors and creditors. Chapter 8, Composition, Permanent Identification, and Responsibilities of Shareholders in Locally Incorporated Covered Entities. Article 20. The shareholders of locally incorporated covered entities may be individuals or, under conditions fixed by the supervisory authority, legal persons whose own shareholders must be clearly identified. The supervisory authority shall particularly avoid situations where there are chains of shareholding companies, each of them holding shares in the others. Article 21. A holding company which holds as subsidiaries, exclusively or principally, one covered entity or more, shall itself be deemed a covered entity, particularly as regards its licensing approval and submission to the supervisory authority. Article 22. A covered entity applying for a license must inform the supervisory authority of the identity of its shareholders who directly or indirectly hold 5% or more of its capital or voting rights. Article 23. Any shareholder, or any group of shareholders acting in concert, shall, directly or through the concerned covered entity, notify to the supervisory authority of any increasing in or transfer of direct or indirect equity holdings in a covered entity which would enable this shareholder or group of shareholders to acquire or to lose 5% of the covered entity's capital or voting rights. Article 24. 1. Any shareholder, or any group of shareholders acting in concert, shall, directly or through the concerned covered entity, obtain the prior authorization of the supervisory authority for taking on or disposing of equity holdings that would directly or indirectly enable this shareholder or group of shareholders to acquire or to lose a half, a third, a fifth, or 1/10 of the capital or voting rights of the covered entity, acquire, or to lose the power of control over the management of the covered entity. 2. The covered entity shall be held accountable for completing the notification and authorization request formalities. If the formalities have not been observed, the vote of the concerned shareholders in the general meeting shall automatically be invalidated, without prejudice to other penalties applicable to such a case. Article 25. Unless otherwise stipulated by ordinary commercial law, the minimum number of shareholders and the level of each stake in the share capital of a covered entity shall not be restricted. However, while examining an application for license, and when scrutinizing a notification or application for authorization to step across a regulatory threshold, the supervisory authority shall, on one hand, look to the presence of one or more influential shareholders, and, on the other hand, shall avoid either the extreme concentration or the excessively wide dispersal of shareholdings. However, a high concentration can be accepted if the concerned shareholder is a foreign bank of high standing. Article 26. For the purposes of this law, a shareholder shall be deemed to be influential from the moment that he directly or indirectly holds at least 20% of the share capital or voting rights, or if he holds de facto decision-making power as a consequence, inter alia, of widely dispersed shareholding. Article 27. If the financial position of a covered entity so warrants, the supervisory authority shall enjoin the influential shareholders, jointly and severally, to increase the net worth until the solvency standards are met. If they refuse to comply, the concerned influential shareholders shall be liable to penalties provided in Article 55(2) below, without prejudice, in case of voluntary liquidation, to actions in meeting disputed liabilities as opposed by creditors or depositors. Chapter 9. Composition, permanent identification and responsibilities of shareholders of the parent company of a covered entity constituted as a branch of a foreign bank. Article 28. A branch of a foreign bank or foreign financial institution licensed to carry on banking or financial activities in Cambodia shall inform the supervisory authority of any change in the composition of the influential shareholding of its parent company, as soon as such a change arises. Article 29. The supervisory authority may call into question the validity of the license previously granted to a branch, if changes referred to in Article 28 above are likely to weaken the financial position or the accountability of the parent company abroad. Article 30. If a branch does not abide by prudential regulations, the supervisory authority shall invite its parent company abroad to reconstitute its capital endowment as mentioned in Article 16(2) of this law or to modify the distribution of assets. Article 31. In case of voluntary liquidation of the parent company abroad, all assets of the foreign branch in Cambodia are earmarked, on a priority basis, for repayment of resident customers, whether they are depositors of securities, gold, or cash, or whether they are creditors. As far as their rights to the assets of the branch at the time of liquidation have been acknowledged by the liquidator of the branch,